Hi, I want to welcome you folks tonight. Now, for those of you that are watching us on YouTube, um, I'll let you know there's no one monitoring this. So there is a chat box and you can chat to your heart's delight. There's nobody there to answer the questions. So part of this is if you do have questions, my email is steve@dalelawfirm.com. And feel free to email me questions and we'll do the best that we can to answer them. We have about 1, 2, 3, 4, 5, 6. We have 6 folks in the audience. We have some other folks that will be showing up as well here, so we'll go through this. The materials that we are presenting tonight, I will make sure that they are emailed to folks that send me an email here, as well as links to some of our other YouTube videos. Now, the reason that we do these workshops here is that what we have found is that if the better prepared you are before you sit down with the attorney, whether you work with a Dale law firm or work with a lesser law firm here, is the better prepared you are, the better the process will be, and the better the trust will be as well. You know, a lot of people have this idea that somehow that if you get a special needs trust, everything will be okay and all your problems will be resolved. And we want you to believe that, but the fact is it's not really true. You know, a special needs trust is just a document here. And part of what the document does is it sets out a process about how your loved one will be provided for if you're doing this for somebody else, or if you're doing a trust for yourself, how you'll be provided for. So once again, I can guarantee you I'm not going to answer all your questions. In fact, you probably will have more questions when I'm done than when we started. But part of this is to learn as much as you can so that when you sit down with the attorney here, that you know the basics of what the trust does. You've explored one of the most important things I'm going to cover is choice of trustees and trustee options here, and what a special needs trust can do and what it can't do. The other thing that I'm going to mention, and we were talking about this with some of the folks before we got started here, is that the way we work at the Dale Law Firm, we have some fabulous staff that work here. And so in most cases, when you come to do your trust with us, you will probably end up working with Jennifer Stenberg, who does a fabulous job of drafting here. And once again, my staff, we are very paralegal driven, and we're very process driven. So one of this is that we're all used to the process here, and our objective today for those that are going to be working with us is going to be on being prepared, understanding how this works, understanding what the challenges are, and moving on. Now, the folks in the audience here today, we have an Achieving Independence guide here, and a lot of what we're going to be doing is going through what is in the guide. And what the guide is really meant to do is, once again, talk about a lot of the issues that are involved with special needs trust here, and also discuss how you can keep the trust up to date and different issues that you might deal with. For those of you that will be working with us here, if you decide to go ahead and work with us, we will send you a guide. Once again, the goal is that the better educated you are, the better prepared you're going to be, and the better process this is going to be. The goal really is not only to produce a document that meets your needs, but to have something that you can understand at least the important parts of the trust. So let's plow through this. So, and as we had talked about here, all of this is in the Achieving Independence Guide, which goes into a lot more detail than what we're going to go through tonight. By the way, for those of you in the audience that are following the PowerPoint slides, we're only going to cover about 2/3 of it, or we would be here until 9 or 10 o'clock, which would make my wife cranky, and we don't want to do that. Okay, so we're going to go through some of the chapters. Now, the first chapter, by the way, being a self-indulgent attorney, the first chapter goes into a fascinating subject, which is me, but that's not what we're going to cover tonight. We're going to cover, some of the more substantive stuff. So let's start off, and I always like to begin with this. Let's start off talking about what is the challenge when you're doing estate planning for a person with a disability. And, when somebody asks you to describe what is the purpose of a special needs trust, the typical answer is to protect eligibility for public benefits. Now, what I want to cover with you is that clearly preservation of public benefits is important, but if you really think about it, it's just a tool. And sometimes people get so focused on public benefits that they really kind of miss the big picture. And focusing only on preservation of benefits, once again, doesn't meet the challenge. Our true objective should be really maximizing quality of life for a beneficiary with a disability, and the benefits are only a tool. So I like to illustrate the challenge as we go through this and why we're so focused on several aspects of planning by introducing somebody named Kathy. Okay, now, by the way, my son, who is a graphic artist, he says that I have it in for Kathy because Kathy has had every disability possible. She's had schizophrenia. She has had Down syndrome. She's had autism. She has had everything you can imagine here. As I like to say, disability doesn't really respect any kind of boundaries. And there are, once again, when we talk about folks with disabilities, there are all sorts of disabilities. But in this case, and for some of you this might not be that difficult, let's imagine that Kathy has autism. And to my knowledge, nobody has ever died of autism. In fact, there seems to be an indication that some of them live longer than you and I. So imagine that she's 17 years old and you come to the estate planning office and you want to get one of these special needs trusts done to make sure that Kathy is provided for the rest of her life. Let's think about what some of the challenges are. So part of this is if she's 17 years old and lives a normal lifespan, actuarially, she's supposed to live 70 years. So imagine the enormity of this. Let's say you get the trust done, and then sadly, you pass away, or we say your trust matures immediately, and the trust goes into administration. What are the challenges we're going to end up dealing with? So, first off, I'm going to cover a section on the basics of public benefits, okay? And I'm going to cover public benefits as they are in 2017, okay? Now, how many in the audience think the rules for public benefits will stay the same for the next 70 years, right? In fact, we're not sure they're going to stay the same for the next 7 months here. So, like, if I do a trust, if our office does a trust for you to preserve SSI and Medi-Cal, Medicaid in other states, under today's rules, did we do our job? Absolutely not. I can guarantee you that benefit rules are going to change. So we better make sure that what we're putting together is going to be able to adjust to whatever might happen in the future. And it may happen in ways that we can't really predict. We don't know what kind of agencies will be there to provide for her needs. We're going to be supplementing programs for her, but what are those programs going to be? Now, for how many of you have loved ones that are regional center clients here? Okay, and I'd say this is pretty typical. About 2/3 of the folks, we're dealing with folks that have that are regional center clients, which means that their loved ones are developmentally disabled and they're getting programs under the regional center system. Today, we have one of the most robust programs in the country. We are the only state that truly has an entitlement system. So today, Kathy would be entitled to benefits under the regional center system. The problem with it is a lot of these programs are hanging by a thin thread, okay? They're poorly funded. It's getting harder and harder to be competitive with these programs because they tend not to pay very well for staff. The staff that are there are truly committed here, or they wouldn't be doing this kind of thing. But if you are, for instance, managing a a regional center program, you probably worry a lot about how am I going to make sure that this agency that I have dedicated my life to is going to continue. Now, I'll bring up one thing. In many ways, we should think about those programs, and if we can, remember them in our wills and our estates. But the thing about it is, Kathy would be guaranteed under the Lanterman Act appropriate services for attendant care, for housing, and that kind of thing. But there's no guarantee that's going to continue for the rest of her life. Now, here's the thing we're going to really focus on a lot towards the end of the program. After doing this almost exclusively for 25 years, the choice of trustees is the single greatest issue about whether this trust is going to work or not work. Okay, and one of the things that I really want you to think about, as you're doing your planning and thinking about this, is really consider what I'm going to talk to you about trustees. Now, we have a number of trustees we work with. In California, we have a number of corporate trustees who do a lot of work in this area. We have a lot of private professional trustees. We have pool trusts and that kind of thing. But can I name a trustee that I can guarantee will provide the level of services that Kathy is going to need for the next 70 years? And anybody who tells you that they can is not being honest with you. Okay, none of these agencies and none of these programs have been around more than a quarter of a century. So we better make sure not only that we have the right trustee, but we have some mechanism to change as trustee options change. So one of the things that we should really think about with a special needs trust is not just think of it as a way to keep folks on a welfare program. Not that that's not important, but really in a lot of cases, depending on the individual, we really want to focus on this as an advocacy tool. Disability tends to be a life-changing experience. I'm going to ask for you in the audience here and those of you that are watching me virtual, do you remember what your life was like before you had a child with a disability? And whether you do or don't, I can guarantee it changed your life, okay? Now, the point of this is that oftentimes we'll turn around and ask folks to take care of our loved ones with disabilities who don't have that experience. And I will tell you, it's like going to a university that you never graduate from. You're always learning and learning and learning. And many of your neighbors, many of the folks in your churches and synagogues and all that, many of your family members really are not experiencing the same thing that you are. And so sometimes we need to step back and be really realistic that the job that we're asking them to do, they may not be equipped to do. And so this is one of those things where learning as much as you can is really important. Here, part of the experience of caring for someone with a disability is advocating and helping to secure resources. As we talk about all the time in our office, we tend to have self-selecting clients. So it's a beautiful evening out tonight here. It's a Wednesday night here, and you folks have chosen to spend your evening with an attorney here talking about special needs trust. So I would say that you probably are here because you're an advocate. Otherwise, you would be enjoying that beautiful evening out there. In all too many cases, the level of care is not intuitive to folks. It's a skill you got to learn. It's got to be practiced and perfected over time through practical experience. By necessity, most of you have become very adept at navigating the disability service system. And there's somebody in the audience we're talking about who was working with one of the advisors we often work with. And, once again, it's a lifelong learning experience to even understand what the issues might be. Persons with disabilities are often subject to abuse and neglect and require a great amount of vigilance. Now, a little bit about my background, just to illustrate this, is that I come from 3 generations of psychiatric nurses, okay? My father was a psychiatric nurse. My grandfather was a psychiatric nurse. I was a psychiatric nurse for 17 years, actually grew up and spent part of my childhood on the grounds of Agnew State Hospital as a family member here. And so, and actually I left nursing after doing 17 years because I worked on some some programs where I witnessed abuse and neglect, and I did something really bad for my career as I turned in somebody for abuse, and then I did it a second time. I moved into the community here and became an advocate for deinstitutionalization. But what I learned is merely moving into the community doesn't mean that you can't be subject to abuse and neglect. In fact, a mentor of mine, Ed Roberts, actually made an observation that you're probably safer in a state hospital than you are in a community if you don't have the right protections in place. So the point of this is that part of good planning for folks who are not able to articulate when they're being abused and neglected is to make sure that the trust is going to have the mechanisms in place and the people in place that can detect that kind of thing. Now, for many of you here, think about this. I was a behavioral nurse when I was a psych nurse here. And part of that is, even if your child is nonverbal, if something is wrong, don't they change their behaviors in ways that just scream out to you that something's wrong here? You know, for instance, if your child starts putting their hands over their head when people walk up to them, they're not shielding themselves from the sun. Somebody has probably abused them. And you know, part of this is good care managers and good advocates can pick up those cues where many of us would miss them. So ideally, we'll go back to this, a special needs trust should have one of its focuses the ability to continue the advocacy if parents or both parents pass away or become incapacitated yourself. And going back to what we were talking about, the difference between a trust and a conservator, the trust is a contract, and in that contract, we would probably want to make sure that not only do we let the trustee know that, you know, if it's appropriate here, that we want to make sure that we want more than just keeping your loved one on a welfare program, but we want to have a focus on making sure that they're not abused, that somebody attends their IPP meeting if they're developmentally disabled to make sure that they get the services they need, or in a lot of cases maybe keeping an eye on them if we're dealing with mental health issues to make sure they're not over-medicated or that sort of thing. Okay, so, and kind of to illustrate this, and I had alluded to this gentleman. This gentleman's name was Ed Roberts. Ed passed away in 1995, and it's hard to imagine that. And somebody had a great influence on my life, and we'll probably talk a little bit about Ed as we go through the presentation here. But one of the things that Ed, one of his favorite sayings is that the disability community is a group that does not discriminate. It will accept any of us at any time. So part of this, as the advocate parent or as the advocate loved one, part of what we want to focus on is not just what happens when I pass away, or as we call it, when your trust matures in the law office here, but what happens here if I lose capacity. Now, another way to look at this, and that's kind of buried, but we have this in each one of our conference rooms, which is called The Definition of Estate Planning from Living Trust, which is a book about a philosophy of estate planning. It isn't even in print any longer, and it's not a book about special needs trust. But a lot of what they focused about was, you know, doing estate planning that really covers all of the needs. And their definition of estate planning is, I want to provide for myself and my loved ones during my lifetime, and upon my incapacity or death, give what I have to who I want, the way I want, when I want, and if I can, save every last fee, tax, or court cost possible. My clients point to that a lot. They're pointing to the fee part here, and we'll get to that in a bit here. But if we kind of go back to this, a lot of estate planning just focuses on death planning. You know, like, I want to make sure that my loved one is going to be able to keep their public benefits when I pass away, or usually it's if I pass away, as if you're going to get out of this thing alive here. But you know, here's the bigger issue that comes up is, what if you have a stroke? What if you get Alzheimer's or that, you know, something along that line, you know, here. And a good estate plan should cover not just when you pass away, but also what if you're unable to be that advocate? And sometimes that's one of the most difficult things to deal with, because most of my folks don't have unlimited funds. And if you do, that's fantastic here. But for most of our folks, that's not how it works. So oftentimes part of it is giving instructions to the trustee and the folks that are involved in the trust about that if something like that happens, how are you going to allocate? What is it how much do you want to focus on your disabled loved one? How much do you want to focus on your needs? How much do you want to focus on your spouse's needs? But part of good estate planning isn't just death planning. It's really focusing on dealing with all those different contingencies. So let's talk a little bit about what a special needs trust is. Now, where did they come from? And the fact is, nobody really knows. And I know some folks think that I invented the special needs trust, but I actually didn't. There's about 6 or 7 people who think they did. And when they all pass away, then I can claim that I did it, but I didn't do it, okay? But it all came this part of the law, okay? Under Social Security, and a lot of what we're going to focus on tonight is preservation of SSI, because a lot of the rules, even for Medi-Cal and IHSS and other essential programs, are really based on Medi-Cal eligibility or on SSI rules, okay, whether you're on SSI or not. So the Social Security definition defines a resource for SSI eligibility as cash or any other property that an individual owns or has the power to convert into cash that's not legally restricted from using for his or her own support and maintenance, okay? If an SSI recipient does not own an asset outright or is legally restricted from direct access to the funds, those assets are not considered a resource for public benefit purposes for eligibility, okay? So let's look at that. What a special needs trust is, it's a form of a spendthrift trust. And think of a trust as a contract, okay? And one of the things that's universal with all special needs trusts is the trustee has sole and absolute discretion about all distributions and the beneficiary has none. So when I'm asked to review a special needs trust to determine whether it's a valid special needs trust or not, what I'm looking for is there any way possible that the beneficiary could force a distribution from the trust? In essence, it's a form of a spendthrift trust, which is a trust where the beneficiary has absolute control and the beneficiary has none. Now, by directing assets that are otherwise intended for the individual into a special needs trust, you're preventing those assets from being counted as available resources or eligibility for benefits. We have trusts that are fairly small. We have trusts that have millions of dollars. I have one trust that has $30 million in it. You would ask yourself, why would you have a $30 million special needs trust? And it's because they wanted to qualify their child for some benefits that they could only get on Medi-Cal. But here's the thing to look at as we go through this, and because my expectation is that within the group here and those of you that are still watching YouTube here, there's going to be a diversity of folks. So looking at it this way, part of a special needs trust is that the beneficiary can make the most reasonable request under the sun, and the trustee has to have the ability to say, no, and you can't make me. Anybody got a problem with that? You know, I mean, you were taking the most vulnerable person in your family and basically taking all of their rights away. Now, there may be some situations where maybe that really is the objective for their own protections, especially if we have problems with vulnerability to with creditors or financial abuse or drug or alcohol problems or that sort of thing. But imagine if your child is perfectly competent. Part of what we are doing when we're doing these trusts is we are taking away their access to these funds. So as we talk about this, depending on what your objectives are, we might want to do some things to try to mitigate that a bit. When you begin planning, your primary focus should be really on providing the best quality of life possible, and then for the preservation of essential services as a tool to meet those objectives. Proper planning should focus on achieving as much independence as possible here, and benefits should not be the sole planning objective. And it's not that the benefits aren't important, but we really should be focusing on quality of life. Now, this is a slide from the Palms, okay? And you'll notice there that where it says Supplemental Needs Trust, it says SI 01120.200B13. What does that mean? Okay. If you call Social Security, does it ever seem like they're reading a script? They're reading a script, okay? And this comes from what is called the POMS, the Program Operation Manual System. Social Security is not great at naming stuff here, but these are directives to eligibility workers about how to handle certain situations. So if you were to go Google SI 01120.200, I think my website comes up first, and after that will come up the Social Security website. And a lot of the classes that we teach talk about how to interpret the POMS and how the rules work. What the POMS say here is a supplemental needs trust, which is just a different name for exactly the same thing, is a type of trust that limits the trustee's discretion as to the purpose of distributions. It typically contains language that distribution should supplement but not supplant sources of income, including SSI and other governmental benefits. So this is something, once again, it wasn't invented by Social Security to give families a break, give me a break at Social Security here, but it's something that they recognize there's a right to, and it's something that is in their regulations. Now we're going to talk mostly tonight about what are called third-party or estate planning special needs trusts. So a third-party trust is established by someone other than the beneficiary as the grantor. The grantor is the person that created the trust. So in the example Social Security gives, a third-party trust may be established by a grandparent for a grandchild. As we'll discuss later, my wife and I have a niece with Down syndrome named Erica, so she's very prominent in a lot of our programs. Here it could be an aunt and uncle for a niece. It could be a brother for a sister. It could be a parent for a child. It just can't be a disabled person for themselves. That is a different kind of trust, and that's not our subject tonight. Now, what Social Security says in their own POMS is be alert for situations where the trust is allegedly established by a third party, somebody other than the disabled person, but in reality it's really created with the beneficiary's own property. I'll give you an example of what they're looking for. Let's say that when your child is born, you start getting all these financial gifts. So this is not my family, but you start getting all these financial gifts, and you go down to the bank and go, what am I going to do with this money? And they say, you can set up a custodian account or an UGMA account or a Gift to Minors Act account, whatever you want to call it. Okay? And you go, great. So you put this together here, and you're going to put the money in there so that you can use it for your child when they go to college. And you can that account can last until they're 18 or 21 if you check the right box. Okay, and let's say, lo and behold, you find out when your child is in their teens that they have autism, and sadly they aren't going to college. Okay, and what happens is when your child turns 18, you go down, get ready to apply for SSI for them, and you discover that since the money really does belong to your child, it's going to interfere with their eligibility for their SSI. So you go, I got a great idea. I'm going to go down to the Dale Law Firm and get one of those special needs trust things, and I'm going to put it in the trust because everybody else made the contributions. That's what they're looking for. They're looking for situations where the funds were owned, even for a moment, by the person with the disability. Here. So everything that goes into the trust has to come from someone else. Now, part of this is special needs trusts do make really good gift vessels, because if you had the trust set up and people make gifts to the trust, then that's not a problem. But in a lot of cases, maybe you didn't know your child was going to have a disability. And so these are the kind of situations you have to deal with. The other thing with a special needs trust is you can have a lot of latitude in a third-party trust. So you can have trusts that turn on and off. So for those of you that want to explore further, we have a workshop on online called on special needs trusts with a focus on mental health. And a lot of what we focus there on is there's a lot of folks with mental health issues where they may have periods of time they really need the protections of the trust and periods of time when they don't. And based on their behaviors and their needs, the trust can turn on and off. You can have multiple beneficiaries in a special needs trust. The other thing is, upon the death of the beneficiary, you can leave the funds to anyone you like with one sad exception. You cannot leave it to the drafting attorney because the state bar really frowns on that kind of thing. So we take ours up front. So that's what we do. So, once again, there's a lot of latitude in third-party trusts. Let's talk a little bit about what I call the four-step process, which is the process that we use here in planning. So the process of creating a special needs trust can seem daunting, okay? And by approaching the planning on a step-by-step basis, it can be a lot less overwhelming. I can't guarantee that it's not going to be stressful, but the whole idea is trying to do this in a step-by-step method. Additionally, the special needs trust is going to be more likely to meet your objective, once again, we have found if you follow this process. So, the first thing we're going to talk about a little bit is that the need to clearly express your intent in your trust and related documents. We'll go back and we'll expand on that. The next step we're going to talk about is choose a management system and a team to carry out your intent. And I'm going to spend a fair amount of time on that. So you could have a really great trust where it's really clear what this thing is supposed to do. And you could have a really good management team. But if you don't put something in this trust, it's not going to do very much at all. So the next one is to develop a funding plan to fulfill your intent. Well, you go, well, we're done with the process. And one thing universal when you're providing for a loved one with a disability is the process is never done, whether we're talking about special needs trusts or anything else. So the last part is to do an update and review periodically. And that is during your lifetime, and it's also when you pass away and your trust matures. We need to have some mechanism where this trust is going to look at itself, and be able to adjust. So we were talking a little bit about irrevocable trust and can you make changes? And part of how we set these things up is that you certainly can make changes while the trust is revocable, and we'll talk about that. But we also put language that allows us to make changes as the laws change, because we know things are going to change. And so we want to give the trustee, trust protector, or somebody the ability to make those changes, because we're recording this in July of 2017, and we have no idea what is going to happen with a lot of the benefits that are provide for our disabled loved ones, and we better be able to adjust this thing as the rules change. So let's talk about intent. Providing supports for a person is not always alternative. Well, we already did that. So why is documenting your intent so important? One of the primary duties of a trustee is to comply with the intent of the grantor, the person setting up the trust. The question always is, when there's a lawsuit or whatever, is what was the grantor thinking when they set up? What was their intent? What was it they were trying to do? If you have a trust that all it says is keep my kid on a welfare program, we're not really giving them much direction about what it is you really wanted them to do. Without proper documentation of your intent and the objectives the trustee is to follow, they're not going to be able to understand what your values are and what your objectives. I'm sorry, this is repetition. So anyway, part of this as we go through this is that, let me just go a couple slides because something's out of order. Okay, here we go. So part of what we want to do is clearly state what your intent is, so that if there's a future trustee who had no idea who you were, they're going to be clear on what is expected of them. Once again, a bare bones trust can only accomplish limited objectives. Now, there's two ways of doing this, okay? And one thing that we do in the special needs trust industry is we all use the same concept and use different names just to keep everybody confused. But let me walk you through this. In the trust itself, and as you begin filling out your worksheet, so all of you out here, you have a third-party planning worksheet, and for those of you that may be watching at home and may be going through the process, we will send you a third-party trust worksheet. Okay, and as we go through this, and blessedly, I'm not going to go through everything, but part of what we're really focusing on is asking you questions about what's important to you. So we're asking you questions like, what kind of housing is it that you'd like to provide for your loved one? What kind of education? What kind of, are there social things you want to continue to support? Things that will never change, okay? And so normally in Article 2 of the trust, the way we set them up, we have a page, and it's not in a huge amount of detail, but we have a page, 2 pages. If you go past 3 pages, you're really overdoing it here, about what is your overall objective. Now, on top of that, we like to suggest you use what's called a journal of intent. Now, sometimes they're called letters of intent. The reason I like to have you think of them as a journal of intent is that a letter kind of seems like you're going to write this one glorious document that's going to put down in writing everything that you want for your loved one and all that. And if you think about it, that's kind of ridiculous, okay? In a way, if you think of it like a journal, and there's no specific format to this, but kind of go through what, not only what you would like in more detail. So you might say that residential needs are amongst the highest priorities I want you to focus on. And I will tell you, in California, disabled or not, housing is a big issue, okay? And you might say that I would like my child to live as independently as possible with certain supports and that kind of thing. But you don't want to go into details. Should it be a group home? Should it be independent living or whatever? In the Journal of Intent, you can go further and say, I've seen this program, I've seen that program. You might say that I've gone to Concord House. I think that would be really fantastic. This would be good for my child. I learned about independent living and supported living skills, and I would like to provide my child with a house, but I would like the supports, all the supports I can get from the regional center to make sure they're safe and live a quality of life. This is where you can get into great detail, and the nice thing is you can make those changes to the details, and you don't need the help of the attorney, okay? Think of the journal as an ongoing documentation of the beneficiary's needs. Now, I've had clients who've done this for over 20 years, and I've had more than a couple of clients who've told me that also it's very therapeutic because you can kind of track the changes and how things develop over time. There's a lot of things that, as parents and advocates, you have in your head that are very useful in the administration of a special needs trust. What medications work, what medications don't work, right? Don't ever give my child stelazine again because they had a terrible side effect that's practically killed them, and please don't do that. What kind of doctor they should see and that kind of thing. Part of this is being an advocate, is being able to pass on that information. So, I kind of alluded that choice of trustee is important. Now, we have been looking for this person for over 25 years. And I'll just say as an aside, I am the trustee of the Golden State Pool Trust, and I have well over 200 beneficiaries that I oversee with my staff, a lot of this with my assistant, Shelley Sinceri, here. And these folks have a lot of time on their hands, and it's a really challenging thing. But as we go through this, I consider myself a pretty good trustee, but I'm not going to make this entire checklist. And if you have somebody who thinks they are, then you probably would want to avoid them. So let's think about what we're going to want that trustee to do. First off, the trustee has absolute discretion over distributions, and the beneficiary has none. Okay? And we're going to talk about how to mitigate that in a minute. But that is central to all special needs trusts. So we better make sure whoever that trustee is going to use their discretion in the best interest of the beneficiary. And that could be not just what distribution should be made and what shouldn't be made. It may also be making judgments like there are times when maybe preservation of the benefits is absolutely essential, and there may be times when maybe it's not that important. An example might be dental care. Denti-Cal for most agencies is a pretty miserable program. Okay, and I'll tell you, when I was a nurse, when it was time to go to the dentist, and I worked on a program for many years with folks with autism, and I will tell you, all of my patients hated going to the dentist almost as much as the nurses hated going with them. But dental work and good teeth are a foundation of health. It may be that rather than send your child to Denti-Cal, which oftentimes will pull your teeth and clean your teeth, but that's about it, you might want them to go to a dentist who would be able to provide maybe a little bit better quality of life. So in that case, we want somebody to really focus on and make good business decisions and use their discretion to really do what is best for your disabled loved one. They need to understand public benefits and keep up with changes in the law. Now, my office is really known for focusing a lot on preservation of public benefits, and we spend an enormous amount of time studying the laws, studying nuances, studying administrative regs and that kind of thing. And I will tell you, it still confuses the hell out of me. Okay, I mean, it is our public benefit system is so hard in some cases to make any sense out of. And, you know, I'm somebody who has a ton of letters after my name, and somehow your cognitively impaired disabled loved one is supposed to get through this system. But here's the thing for the trustee. It may be that they don't spend all their time studying public benefits rules, and I would suggest that they not. There are folks that can really help them with that. And it's not just the attorney. We have somebody who's been working with a gentleman named Jim Hike, who excels in studying regional center programs and that kind of thing. So it's something that can be purchased. But, you know, part of this is not just preservation of benefits. It's learning how to leverage it, and then sometimes learning when it just isn't worth the hassle. Somebody who can wisely invest and conform to all statutory fiduciary requirements. Look at it this way. For lack of a better term, let's say you have a child with a disability and you have a typical child, okay? And let's say you're trying to be equal, which is absolutely impossible with children because children are never equal, disabled or not. But let's say that's your objective. So let's say you buy a life insurance policy and $500,000 goes to the special needs trust and $500,000 goes directly to your typical child. Well, if your typical child here misinvests the money or does something stupid with it, they have more options typically than your child with the disability here. And so, you know, that's very common to happen. But typically for a child with a disability, if that money is mismanaged, if it is invested incorrectly, usually there's not a second chance to recover those funds. So part of this is making sure the investments are prudent. Also making sure usually that they're conservative. And a lot of the programs that we have on YouTube also talk about how we can tax leverage the investments. So working and having the investments done correctly and prudently, and this is not a time to be day trading with those funds here. It's important. And unfortunately, there's a lot of trustees that are family members who maybe don't understand that, and they're looking at the enormity of the job, and they'll get into risky investments, and they'll get themselves and your disabled loved one in trouble. Now, because we don't have a ton of time, and maybe you can count this as a blessing, I'm not going to spend a ton of time on taxes, but it would be really good if we can get a really good tax benefit or tax leverage things with the trust as well. And one of the series of programs that we have, and if you're doing your planning, here, and you have a large qualified plan, which would be a pension, a 401k, an IRA. There are strategies where you can try to take as little as you can, leave as much as you can for your disabled loved one. In the right situation, it's a very good thing to do as far as funding the trust, but also we have had multi-million-dollar qualified plans left to special needs trusts, which paid no taxes in the end at all, depending on the situation. This has never been more important than it is today. You have to keep perfect books. Social Security is reviewing every special needs trust they can get their hands on, okay? And we've seen that accelerated. Now, if we have a trustee who keeps really good books and keeps records, then there's really nothing to fear at all. If you have somebody who throws all the receipts in a shoebox, or worse, doesn't keep the receipts at all, and they get audited and they ask you, Mr. Trustee, what did you use these funds on? And you go, well, I'm not really clear. Well, can you show me receipts? No, I can't. We're going to have a problem. So keeping records is incredibly important, especially today with Social Security, to a degree with Medi-Cal, because they really are reviewing these things. Somebody who can provide advocacy and prevent abuse. As we start talking about models, we work with a lot of professional care managers, and we'll talk about that. But these are private social workers that are often trained to detect situations that are dangerous and also detect signs of abuse and neglect. Now, here's the thing that I would have a hard time. I think pretty highly of myself, and I think I could do most of these things, although I don't keep records here. And if you saw how I invested my 401k, you say, this guy's not investing my money. But I have people who do it for me, and I have people who keep my books and all that. But you got to be immortal. You got to outlive Kathy, okay? And I'm here to tell you, if I'm the trustee for your 17-year-old, there's a pretty good chance I won't be being a trustee in 70 years. In fact, I'd say it's pretty much a certainty, okay? And I have had, for those of you that are watching on YouTube, you can't see this, but we have an enormously large table that some of the folks are sitting at. We do that for a couple of reasons, because we get a lot of people around the table. I have had people sit at that table wanting to name their 6 and 7-year-old nieces as trustees of their disabled child's trust, because they want to make sure that somebody's going to outlive them. Now, how reasonable is that? I mean, that just doesn't make any sense at all. But the problem that a lot of families deal with is, who's going to be there for my child's lifetime? And so part of this is to be realistic. So let's talk about some models. Now, first off, there is no such thing as the ideal trustee. Even me, okay? Nobody meets that entire list. But if we take that list and we kind of divide it into spheres, and what I'm going for is a checks and balance up here, and how you divide it up almost doesn't matter. But in this case, as we talk about these models, what we've done is we've taken the attributes that are associated with advocacy and we put them in one sphere. We've taken the attributes that have to do with accountability and we put them in another sphere. And we put the attributes for the financial part and put this in another sphere. So what does this really look like? So I'm going to go through a couple of models. Now, I do a program for NAMI from time to time called Why You Shouldn't Make Your Daughter the Trustee of Your Bipolar Son's Special Needs Trust. It's not a good idea. And I spend my time going through story after story after story about why this can destroy a relationship. And as I'm going to talk about, there's a role for family members and siblings and that kind of thing here. But in my experience, I've rarely seen that work. There are exceptions to this, okay? And, for instance, my associate, who, just happens to be one of the leading special needs trust attorneys in the country. I have a feeling she can manage her sister's special needs trust, and in fact, she does here. But one of these things that I'm asking you is that you might insist that, yes, my child is an exception to this, and I want my daughter to be the trustee of my daughter's special needs trust. but I want to kind of have you hear me out. The other part of this is that you might have a family member as a trustee, but we might want to put in what I call the I told you so clause, which is in the event that your child is not able to do it. And it may be that we get a lot of folks where they try as best they can, but if you think about it, one sibling being in charge of another sibling is kind of an unnatural thing, like it or not. If I were the trustee over my brothers and sisters' trusts, and none of them are at least diagnosed disabled here, I would straighten them out right away. But what do you think that's going to do with our relationship? It probably would be bad. So here's a model we use a lot. So in this case, we're going to have a trustee, and the trustee is going to manage the funds, make the distributions, make sure the taxes are done, and keep the records. Now, there's a number of folks that we use here. So for instance, we use a lot of private professional fiduciaries. For some of you, as you walk out, you're going to notice that there is an enormous amount of brochures out there from all sorts of trustees and trustee services and that kind of thing, including Jim Ike, so he always makes sure they're there here. So we have corporate trustees, we have private professional fiduciaries. We're going to talk a little bit about pooled trusts in a bit. With that, the trustee is directed by an advisory committee, which gives guidance to the distributions, can amend the trust or replace the trustee. Think about it. When 25 years ago, when I first got started doing this, and I learned the hard way the value of professional trustees, my favorite trustee was San Juan Bank. They were so good. There is no San Juan Bank today. We used A.G. Edwards a long time because they were around for 150 years, so they're always going to be around. Well, whoops, that didn't work out too well either. And sometimes it's not entirely whether they're in business or not, but trust companies are only as good as the people that work there. So I've seen trust companies that do an enormously good job, and they'll have a change of personnel or a change of management, and things change definitely. So if you name really big bank and trust who's maybe done a very good job, and we have some trustees we've worked with for 20 years that we have a lot of faith in, can I guarantee that they're going to provide for Kathy the way that she needs to be provided for the next 70 years? And the answer is absolutely not. So we better have some way to hire and fire that trustee. I mean, it just doesn't make sense to give somebody a lifetime job when they're not accountable. We also kind of have a philosophy in the Dale Law Firm is that some trustees don't like to be fired. Well, I've been fired. I don't like it either, or don't like the ability of it. But, you know, to me, if you've got a trustee that isn't going to allow themselves to be accountable, I would get up and walk out and find myself another trustee. Now, with this, and this is really important in a lot of these trusts, and a lot of what I've learned as things have evolved. Okay, here, just to tell you the truth, for some of the clients that I had in the early years, I had no idea what I was doing, you know. But as we started doing these trusts and started learning, you know, the value of professional trustees, things got better, but there was a component that was missing. The trustee is not a social worker. They're not a social service professional. And the thing that comes up is that we may have a trustee who's really good at keeping records, and we're going to have them work under the oversight of this advisory committee, which could be family or friends here. But an element that we try to add is what's called a professional care manager. Once again, in our lobby, we have a lot of brochures for professional care managers. Who are these folks? Okay, their major focus are working with seniors. Here, for people over 65, and I just turned 65, so I guess I could qualify for a care manager, but I'm going to try to hang on for a bit. But what they do, their major business is providing oversight for folks that are elderly. But there's a number of great providers who also have experience with mental health, developmental disabilities, and that kind of thing. So for instance, a lot of the agencies we work with, we include care managers to go out and do periodic assessments, look for signs of abuse and neglect. Are they over-medicated? I had a care manager this week that I hired for one of my pooled trust beneficiaries who we were wondering why we were having some behavior problems with our beneficiary, and lo and behold came down and found out that they were medicating this poor person out of their mind here, and lo and behold, when we changed the medication and reduced it, the behavior stopped. Things that family members just wouldn't be able to identify. By doing this, basically we have a system that is going to be able to work with to provide the care, is going to be able to adjust as time goes on here, and it's going to be able to focus on making sure that the needs of our beneficiary are taken care of. By the way, for those of you that are watching, if you have family members that are really interested in disability and are looking for a really cool career, care management is a wonderful thing to get into. Now, with this kind of model, and part of this sitting down and working with a law office that has experience with special needs trusts, we want to talk about what models work and what don't work, but we want to talk about practicality. So one of the practical issues when we're dealing with this kind of model is most fiduciaries are going to want a minimum of $500,000 in that trust, and most corporate trustees are going to want $1 million. Okay, now for those of us that are younger and insurable, you can buy insurance, and there's all sorts of ways of doing that here. But for a lot of us here, especially families that are struggling to try to provide for the needs of their disabled loved one, it may be that I would love to leave my child $1 million, but it could be that that is just not practical. So one of the things when you sit down with Jennifer and her team here is not just what model works and what model doesn't and that kind of thing, but it's what I'm doing, do you think it's practical? And I think that's a lot of what we bring to the table here, is that not only do we set these things up, but we get involved in the administration, which is enormously important when you're counseling folks about what's going to work and what doesn't work. Let's look at another model, and we use this a lot for folks with mental health issues. We're going to say, and this is a variation of the same thing. We have a trustee that manages the funds, keeps the distributions, does the taxes, a care manager that interacts with the beneficiary. We use this a lot with folks with severe mental health issues. The reason for that is we have somebody with compliance issues and that sort of thing, and there's an advisory committee. The beneficiary may just hound that advisory committee until they give up into submission, okay? And once again, we want to fit this to the situation. Or we may have a situation where we have severe medical needs, and maybe we need something where we're going to try to reduce the involvement of care or try to be more focused on decision making so we can make decisions more quickly. The care manager is usually an essential part of this, and especially in severe mental health issues, almost all the interactions are going to be with the care manager. Almost none of them will be with the trustee. The trustee is going to take direction from the care manager. In that, we're going to have a trust protector. Now, what a trust protector is a person, sometimes two, but almost always one, who's going to have the power to hire and fire and amend the trust, and we're going to limit their powers to those duties. Now, when you have the power to hire and fire, that does give you a lot of power. But part of what we want to do is we don't want them involved in the day-to-day activities, because the danger of them being hounded by the beneficiary into submission. I had a case a number of years ago where I was giving it at NAMI and was actually one of the not making your daughter the trustee of your bipolar son special needs trust, and somebody whose mother was health was failing brought her in, and she had been named as the trustee, and she said she felt like I was talking directly to her, and I guess in a way I was. And the issue was that her sister, who she very much loved, had schizophrenia and a lot of substance abuse issues, and she had been named as the trustee of her sister's trust, and she knew her sister was going to drive her out of her mind. And so we adjusted the trust to make her the trust protector rather than the trustee. Mom passed away. The first thing that daughter asked for is that she wanted the trustee to buy an RV, so she and her newly found boyfriend, who apparently they had kind of a little problem with methamphetamines, She wanted them to buy a van or a RV so they could travel across the country. The trustee said, no, we're not going to do that. First of all, you don't have a driver's license, and you also have a record that as long as your arm. Why don't you work on, achieving some other goals here? And if you can show me that you're responsible and can handle it, maybe eventually we'll buy you an automobile. Oh, this really just ticked her off. And so she called her sister and said, you got to do something. Mom would never have wanted that. Well, yes, she would. And you got to do something. And she was able to say, well, I don't know why, but Mom did not make me the trustee, and I don't have the ability to make him do that And so she didn't get the RV. I got the call later, and I got a box of peaches as a thank you here, because she said, had I been the trustee, it probably would have put my marriage on the rocks. There's an example where we might look at that kind of thing. By the way, for something like this, once again, you probably need at least $200,000 or $300,000. More is better. And by the way, I get this question all the time: how much should I put in my child special needs trust? And the answer is, there's so many factors, it's really hard to say. And in a lot of cases, it really has to do with what can you afford. Let's say I would love to have one of these trusts, and I would love to be able to provide all these quality of life things and all this oversight and all that. But try as I might, the best I'm going to do is be able to leave my child, for instance, the ability to live in my house, and maybe $100,000 on the side, okay? And housing, once again, becomes a big issue. And in a case like that, we want to be really careful about what our costs are going to be. So this is what I would call a limited purpose trust. And I'll tell you, with housing, and we're very focused on housing, if you're going to leave your loved one a home, leave enough money to make sure the roof is not going to leak. If they're getting $895.40 a month, it's kind of hard to feed yourself and make sure the roof doesn't leak. So once again, we probably evict 2 or 3 people a year, oftentimes live in the home that they grew up in, and it's not a pleasant thing to do because the house is falling down around them. So in this case, we might say our focus in that example is that, trustees, what I want you to do is focus entirely on making sure the house is safe and making sure it's appropriate here. And if you need to go beyond that, we're going to give you the ability to hire someone to assist you, but we're really going to narrowly focus what this thing is going to be. Here's our last model, and this is a new model here for us. All of the first models, well, the first 2 models are what I would call the retail models. Okay, so in those models, which work very well in the right situation, for instance, corporate trustees normally will charge somewhere about 1%, maybe with investments, it might be up to 1.3. And whenever you're looking at it, sometimes you have to ask a lot of questions about what the real cost is. And if there's enough in the trust, that may be fine. Private professional fiduciaries charge somewhere between 100 and 125. Some are a little bit more, some are a little bit less. And depending on how much work is involved, the charges may be modest or they could be enormous. Okay, but and the cost of a care manager usually is going to run somewhere between like 100 and 125 an hour. Now, for what they do, they're worth their weight in gold. But you can imagine, in some situations, a lot of funds could be going for those expenses. Well, there's another animal called a pooled special needs trust. Now, I happen to be the trustee of a pooled trust. The traditional way of using a pooled trust is to sign what's called a Joinder Agreement. It's a contract where you're going to leave the funds in the trust, and it's going to function like any other special needs trust. So you go, well, why wouldn't I just do that? Well, here's the problem. If you join by a Joinder Agreement, you've just eliminated all options for changing if, for instance, for some reason that trust isn't working in your child's best interest, or here, if there's a better option that comes along. I think key in all of this is to be able to be flexible and be able to have some choices and be able to adjust as time goes on. And I will tell you, and I'm involved in a project right now that we're hoping will come about, is there are many families across the country, all over the world, but across the country, that have the same concern, like how am I going to provide for the needs of my disabled loved one? And also, how can I try to do it in a way that is most cost effective here? And pooled trusts oftentimes are what I call the wholesale model, because what they're doing is they are pooling the funds of hundreds, sometimes thousands of beneficiaries here, and by doing that, they can often get services at a reduced rate. So, for instance, some pooled trusts like Achieva in Pennsylvania and the Colorado Fund Pooled Trust happens to be in Colorado. Here, they have their own care managers, and once again, the charges for using them is a fraction of what you pay on the retail market. So, what we suggest you do is that you create a separate trust, and you put in that trust the ability to hire the pooled trust to manage the trust, but have some checks and balances that if for some reason it's not working out, or there's a trust or a service that would do a better job for less money, why wouldn't you want that? So in that case, the pooled trust manages the funds, makes the distributions, does the taxes, keeps the records. They're sharing their resources over hundreds. We have 200 beneficiaries here. Some trusts have thousands of beneficiaries. They can include care management or advocacy services, often at a lower cost than the normal rate. But ideally, the pooled trust is going to be accountable to family or a circle of support, meaning somebody that cares or at least will oversee whether it's working. So, so the way we like to set these things up is that we would, if you wanted to use a pooled trust, so let's say it was even the Golden State Pooled Trust, you would say that the trust would be managed by the Golden State Pooled Trust, comma, or a private professional fiduciary, corporate trustee, or pooled trust of the advisory committee's choosing. Okay, and we use that kind of language in many of the models. This gives the ability to adjust as time goes on and be able to leave it up to the advisory committee under the counsel, ideally, of a law firm like ours, about what is the right group at this time, and then from time to time look at this and see if that makes sense. Last thing we'll talk about here is funding your special needs trust. Consider the trust a vehicle. The trustee is a driver, but if you don't put some fuel in it, it's not going to do very much at all, okay? And so one of the biggest mistakes we see is not properly funding your trust. And that's true in all estate plans, but especially with special needs trusts. What does that mean? So let's say you get this trust together, you've got very clear on what it is you want this thing to achieve here. You have feel real confident about your trustee, and you've chosen a model that you feel is going to, take advantage of working with family and friends that are going to help guide this thing on an advisory committee or a trust protector, and you're feeling really confident here. And let's say that you have some life insurance and other assets you're going to leave to the trust. But one of the things you have to do is you have to make sure that everything that's going to go to your disabled loved one is either an asset of the trust or makes the trust the beneficiary. Now, part of what we'll do is when we go through this with you is we'll go through what things do you title into your estate plan, what things do you make as the beneficiary, and that kind of thing. But the fact is most of us don't keep those things up. So if you're working with a financial advisor, a good financial advisor should be able to work with you on choosing the right portfolio and maintaining that and making sure it meets your objectives. But the other thing they should do is also work with you to make sure that all the assets you own are titled or an asset of that trust. So once again, we very much like working with investment advisors, and if you have one, they can be a very important part of the team. One thing I will mention is on our website, we do have a video that we suggest you watch maybe every other year called How to Update Your Special Needs Trust. And part of it, it goes through a checklist about things you ought to consider to keep this thing up to date. So the last thing we're going to cover is just very briefly, then I can take a few questions, and then it's time to take myself and Mrs. Dale home, is updating and review the trust. Okay, so a question I get all the time is how often should I have my special needs trust reviewed by my attorney? And the answer is the typical lawyer's answer, which is it depends. Okay, so that's the first thing they teach you in law school. Never give a clear answer. Just always say it depends. Okay, as unsatisfying as that is, this information might kind of give you some guidance. And by the way, part of this is, and we have links to this, I'm a member of the Special Needs Alliance, and I wrote an article that is with the Special Needs Alliance that covers these concepts on updating your special needs trust with a self-review. So one of the things you might want to consider is an annual, no less than a biannual review that you undertake with yourself or with the assistance of your financial and tax advisor to help you do this. Once you've performed this self-check, and part of the self-check here is looking at, are all my assets properly titled into my trust? Have there been changes in my child's needs? Have there been changes in my financial situation, one way or the other? Maybe when you set this trust up years ago, your financial situation was different here, and people's assets go up and assets go down. And so if they've gone down, for instance, it could be that what you have is really impractical. And that might be something where it's time to really look at this and say, well, I need to make a few adjustments here. After you're done with the review, then if there are changes you need to make, that's a good time to call the attorney. That does a couple of things, is not that we don't want to talk to you, but a lot of the things we normally review. The other thing that normally we want you to review is who is the trustee, who's on the advisory committee, and that kind of thing. So if you have like Uncle Ed, who was named as the trust protector, for instance, for your child with a disability, but Uncle Ed is in prison, maybe he's not a good choice right now. Maybe we should be looking at somebody else, things like that. After that's all done, then that'll pretty much give you a good idea about whether it's time to go see the attorney. That way you're better prepared, and the other thing is, that way you're spending less legal money on the review, which probably could be spent on other things. Anyway, that's as far as I'm going to go tonight. Normally with this program, what we're doing, we'll go a little bit into the ABLE Act. By the way, I have 24 videos on the ABLE Act, so if you want to learn about the ABLE Act, go to our YouTube channel and look for the playlist on this. Couple of things before we close, and what we'll do is I can take some questions here, but couple of things to keep in mind. Right now, we're going through a lot of changes. I think that planning for special needs has never been more important than it is today. The other thing that we really need to look at is that a lot of the advocacy organizations like NAMI, like the ARC, like UCP and all that, they're doing a tremendous job, and they're really doing their best to try to advocate and educate policymakers about why we should not be cutting the services. We should be expanding services for folks with disabilities. Remember, I told you that you're a different person today than you were before you joined our community. Well, there's a lot of folks, including legislators, who I don't really understand what the needs are. I know for a lot of the families I work with, if their child is disabled from an accident or that kind of thing, and they start learning about our system, they all say exactly the same thing. I had no idea how challenging this is. So under the best of circumstances, this is a challenging thing to do. So part of what I'd like you to think about is, obviously our focus is on getting the best quality of life for your disabled loved one that we can. But as we do this, think about the organizations that serve us. With that, I want to thank you. And with that, and I'll leave this on, so just remember, if you're going to ask an intimidating question. We've got people that are probably watching. Do we have any questions, or I'd be surprised, or did I answer everybody's question? Yes.
Okay, so let's say you have no will, you have no trust of any kind, and you're trying to start this process, and you have a person who has a disability that you're trying to do planning because you're getting older.
Yeah.
So, and I'm planning on using your law firm. So, what would be the next step? Making an appointment?
So the question would be, so what would be the next step after we go through this? Part of this would be to fill out the intake sheet, make an appointment. What we try to do in the law firm, if we can, here is we try to make this like a 3-step process. So the first step, after you turn in the intake sheet, here is you're going to meet with Jennifer and her team, and she's going to sit down with you probably for about an hour or so, and she's going to go through this with you, and she's going to ask you a lot of questions, and it should be interactive. You should be asking her questions as well. And what she'll be looking at, she'll be asking you to bring in information about your child's benefits and other issues along that line. After you get the trust together here, the next step is that Jennifer and her drafting team, a lot of that is Lysandra Wilson. So many of you will be working with Lysandra Wilson. Jennifer and Lysandra will draft the trust, and they'll do their very best to get it back to you as soon as possible. What they will do with the documents is they will highlight what you really need to focus on. We are members of a group called Wealth Council, and we actually wrote the Wealth Council Special Needs Trust, and we're also members of Elder Council. So almost all attorneys use forms, and so we actually are responsible for those forms, and there's about 10,000 offices that use that. So they, believe it or not, we all start with the software program. We don't sit down and type out everybody's trust. That would just be kind of silly. But we go through and we modify it. These things will tend to be customized. There's an enormous amount of boilerplate in that trust. This is the hard part, especially if you're an engineer. Here is they're going to highlight what you really need to go through. Okay, if you want to go through the boilerplate, just have at it here. But what you really want to focus on is, do we have the right people in place? Do we have the right objectives? Do we, does this really reflect what you want? Do we have the right remainder beneficiaries? Do we have the right trustees? And do I understand what the heck this thing is? What she'll send you normally is a PDF, which is highlighted, and they'll do a review over the phone to make sure that everything is correct, that there's always questions. It's a learning process. Here it's a two-way learning process. Part of the process is for you to teach the drafting team what it is you want and the challenges, and what have you seen, what works, what doesn't work. Sometimes there's just not an answer here, but you're not just buying a document, you're buying the experience of the law firm here, and their job is to once again work with you, teach here, and make sure this is all reflected. So you go through that and highlight, it's all highlighted, and then the next step after that will be the signing. Now, even during the signing, it's rare that changes aren't made. So oftentimes this is a 2-level office, and so the signing area is downstairs, the drafting area is upstairs. So you'll see Lysandra running up and down and up and down. In some cases, the less you make her run up and down, the better. She'll appreciate that here. But part of it is these tend to be very customized documents. That's basically how we work here. Other offices work in different ways. Once again, the more prepared you are before you sit down, the better. The other thing with it is, hopefully I answered some questions and talked about the process, but I know that even going through this probably generates more questions than you had when you started. So if you have a situation where you're ready to go, but there's just some issue that you're just not comfortable beforehand, the goal, part of my job is to get you to the place where you feel comfortable. Not that you're going to have every answer, every question answered, because that's just not reasonable here. But that, for instance, trustees may be a big issue, or is this appropriate, or that kind of thing. what we try to do is to try to answer those questions beforehand as best we can, so that basically you're prepared to sit down and get down to business.
So how would that before process happen? Because I do have a million questions, I'm sure other people may too. In other words, would it still be making that appointment with Jennifer, or would it
What you would do is if there's these threshold questions, you probably would have a phone appointment with me or Jennifer beforehand.
Okay.
And usually, if it's just going through a few questions, we don't charge for it. If we're getting into something where it's taking hours and hours, there's a certain point where we turn the meter on.
Sure. Okay, good, thank you.
I got payroll. So anyway, there we go. And by the way, we are officially done, but I can answer a few more questions and then I got to go home. Yes, ma'am.
Is there a minimum amount that you need to start funding some services?
The question is there a minimum amount? And the answer is technically no, okay? But there can be practical amounts. So for instance, if you were looking at putting $50,000 in a special needs trust, you might actually want to look at a pooled trust with a joinder agreement. We've done them for that low. It's hard to come up with a solid dollar amount, but part of it is you need to get enough longevity out of this thing to make it worthwhile. I think what I hear from my clients is it's not an awful process, but it's not an easy process. Nothing with disability is an easy process. A lot of it has to do more with what are the options, because you go back in this, and the numbers keep changing. But part of it is, for instance, if you're looking at using a professional trustee, there's certain thresholds you have to hit, or they're just not going to take it. So this is one of those it depends kind of questions, but it's a very valid question, and the specifics in your situation is something you'd certainly want to check out beforehand. The other thing that I'll kind of mention is, almost without exception, we do separate special needs trusts for any number of reasons, and in the book we cover that. So what we'll do is, if you have an estate plan or have us do a living trust, what we'll do is it's a separate document, and whatever is going to your child with a disability will pour over into that document. Now, if it turns out that the most you can leave is maybe $50,000 or something like that, that might be one of those cases where we might have an embedded trust, a sub-trust, whatever you want to call it. But we believe that that in all but a few situations, a separate trust is the way to go. Not the least of which is that when the trust is funded, and normally we don't fund these trusts until you pass away, unless you have a lot of money and there's some tax reasons or that kind of thing. But if you have an estate less than $5 million, maybe for a couple, and maybe $3 million for a single person, and I would say that is 95% of my clients, and that certainly is me too. There's probably not a tax reason for doing it. When we have folks with larger estates and have some disposable assets, we might have you funded earlier for tax purposes, but once it goes in the trust, it's gone. It's for your child. So there's a lot of different thoughts about it. Of how that's done. Any other questions? And otherwise, it looks like a lovely dusk out there. We'll have you the last question, and then honey, we're going home soon. So anyway.
This is along the lines of funding the trust.
Yes.
So if you have retirement, IRAs, and you still need maybe the income from that IRA to yourself survive, how does
Let's cover that just for a bit, okay? Stick with me on this. Let's say what you have is a large IRA, 401k, or that kind of thing. You can't leave the IRA to somebody until you pass away. Now, one strategy that a lot of folks will do is take as little as you can and save as much as you can for your disabled loved one. If you have some other assets to pull from there. One of the things that comes up that we all learn is we put off the taxes on all that money we set up for our future, and then we get to learn that every dollar we put off, we're going to pay ordinary taxes on when we start drawing it out. So it might be, there's a couple of examples where this comes out. For a single person, it might be better if you have other investments to pull those investments and put off using the IRA 401k as long as you can. Okay, here, and I'll give you another example in a minute if you're a couple. So what you do is when you pass away, whatever is left, you leave it to the special needs trust, and you have to do it in a specific way, and there has to be specific language. Now here's the thing that comes up. Okay, you can leave IRAs and 401ks to special needs trusts if it has the right language. But the way it works is there have to be minimum distributions that are taken out of the trust. So there's a woman named Natalie Choate who is kind of like the queen of qualified plans here, and any financial advisor knows who Natalie Choate is, and I've been fortunate to meet with her several times here. And so she calls it putting a mortgage on your retirement plans. Like, you can put it off, but eventually the government's going to call that mortgage because they want those tax dollars. Okay, here, and so they'll let you put it off, but they won't let you put it off forever, and that's why you have to take minimum distributions. Let's say what you have left over is a couple $100,000 in an IRA special needs trust, and you leave it to the trust. Okay, and you got to stick with me on this. It has to be taken over the actuarial life of the beneficiary and the remainder beneficiary. Okay, and so the way this works is, let's say your child, to make the math easy, is 50 years old when you pass away. Okay, and let's say that when they pass away, it's going to go to their child, your grandchild. By definition, that's their descendant, and you can't have a descendant older than you, so the measuring life is going to be the 50-year-old child. The minimum distributions that have to be taken out of that fund to go in the special needs trust has to be, it works on a table, and this is what I'm going to tell you is going to get you within 3%. The government says we're all going to live to be 87 years old. So the government knows that, so there we go. And it doesn't matter if you're on your deathbed. The government says you're going to live until you're 87 years old. So what you do is you take 87 and subtract 50, and the first year minimum distributions would be 1/37th. The next year would be 1/36th. The next one would be 1/35th, and so on, if the 50-year-old is your measuring life. Now here's the thing that comes up, and minimum is minimum. So let's say what your child needs is assistance with attendant care, which is a deductible expense. So let's say the minimum distribution is $3,000, but what the trustee really needs is $5,000. So they pull out the $5,000, put it in the trust. That is ordinary income, and if it stays in that trust, you're going to pay a whopping tax. But if the trustee pays the caregiver directly, then we've got two questions to ask. Did the beneficiary get income for benefits? Income for benefits is any cash you gave to the child. How much cash did we give the kid? 0. No benefits income. Taxable income is any benefits they got, and the income follows that. So for taxable income, it could be that they got $6,000 of taxable income, of which almost all of that will be tax deductible. And then there's another thing called the Qualified Disability Trust, where you get a $4,000 discount on top of that. So we have emptied out, depending on the situation, multi-million-dollar trusts and never paid a cent of tax. It depends on the situation. And in a lot of situations, especially, I mean, there's two things that are true. Your disabled child is probably in the lowest tax bracket in the family. And oftentimes they'll have a lot of deductible expenses, but they've got no income, right? So you can see how this works. Let me give this one other variation. Let's say, and I had a case where we knew somebody was going to pass away, a father was going to pass away. And what they had done is they had set up a special needs trust, not set up by us, but they called us in at the last minute, and they had bought a nice big healthy life insurance for the special needs trust on his life. And they were going to leave this IRA to his spouse. Well, she's in a very high tax bracket. The last thing that she needed was more income, right? And I looked at that and go, we've got that ass backwards. Why don't we switch it, and why don't we leave all that nice tax-free income to the wife and leave all that taxable income into the special needs trust? And once again, we got a really nice, almost offensive result out of it in that case, that IRA has been emptied out and put into other investments because we kept pulling out the income to offset the taxes. The point of this, even if you're not following me, which is pretty easy to do, is that if you are in a situation with a substantial qualified plan, we have all sorts of materials that you can give to your tax advisors to explain this to them, because this can be a strategy where if you can provide for your loved one with a disability and get a good tax result, well, what's wrong with that? With that, I want to thank you, and it's time to take Mrs. Dale home for dinner. I want to thank you for coming. Please remember the disability organizations that take care of us. I want to thank you so much.